18th of February, the order has been passed, my lord. Urgent, I am retiring in May, my lord. My pay fixation has been
When
denied.
did you apply for certified public?
Immediately, 19th of February. 18th, the last order, 19th of February, I applied.
You will get
File
it.
has not been gone to the.
When are you going to retire?
I will be retiring. My pay fixation has been denied
When are you retiring?
in the month of May.
Wait for
9th of May.
Yes.
I mentioned one review application. My lord, sitting with my lord Justice Parthasarathi Chatterjee has passed the order. They have filed the review, that eviction order of Salt Lake property. But if any precedent is appearing in the monthly list, if any precedent be given in the matter, my lord, I mentioned personally, your lordship.
No, monthly list it is there. Keep a watch. Wait for this week latest.
Yes.
Yes.
Please issue. But for the appellant, my lord. But I'll just, before my lord, I just open up this matter, my lord, I just must point out that in this matter, my lord, though the name, my lord, does not transpire, but my lord, Mr. Atreya Chakraborty, my lord, appeared for the petition.
List stop. Let the matter be placed.
Time for the appellant in this matter.
No, appearing for the commission and for the state. State.
अरे तुम्ही आता स्टेट
Hey, what are you? Hey, তপতি আমাকে একটু দিয়ে তপতি really maybe return.
What section 5 you have filed? No explanation.
My lord,
It's the discretion order ground, Mr. Cruz. Either you withdraw and file fresh application for transfer. How can we revive the issue 2022 dismissal?
no, my lord. It is 2024.
Order was passed when?
Yes, my lord.
20th November
2024.
There is a delay, na? How many days?
My lord, 414 days. My lord, your lordship, my lord,
440, that is above a year.
414.
Uh,
My lord, since my lord,
to us, what is the explanation?
explanation, my lord,
Just because subsequently another order has been passed, that cannot be a ground for section 5.
almost, my lord, what happened, my lord, petitioner is waiting
order
for
please,
the
sir.
normal function.
Yes, sir.
It is averted in this. After passing this order, I have not communicated this order, but DI ought to, my lord, state learned advocate for the state duly represented by the state, my lord, DI. My lord, DI even not state, DI is also sitting right. So, my lord, I am paying only this much. This willing teacher concept should modify. My lord, that much I am only paying.
Please come to your section 5 application.
Yes, my lord, section 5. I have stated, my lord, I am waiting for the normal function.
Place the paragraph. Which paragraph you want to place? You place that paragraph.
My lord, in paragraph 9, my lord, I have stated, my lord, subsequent, my lord, there is an observation of the honorable division bench that this willing part should not, my lord, should not be incorporated. This willing
Paragraph?
paragraph 9 of my section 5 application. My lord, this,
When was your application for transfer? Tell us.
yes, my lord. My transfer application is, my lord,
2022.
2022. My lord, I am waiting
You
for the
filed the writ petition after 2 years. Now the court has incorporated that word willing.
willing.
So you should have preferred the appeal contemporaneously.
Contemporaneously, but subject to
How
correction.
can we help you? Tell
My
us.
lord, my lord, only this much. My lord, I am not saying setting aside this order. My lord, only since my lord has passed, my lord, several order, my lord. So, my lord, it is, my lord.
The petitioner accepted the order only after your lordship has intervened this word willing.
Petitioner not
He
communicated.
admitted me, para 9, he has admitted that.
At a 9.
Para 9 of the section 5, your
Yes,
lordship
yes, my
kindly.
lord, this is true, my lord. I have admitted, my lord. After, my lord, since my lord,
After seeing your lordship's order, you'll
since my lord, other candidate is, my lord, is getting facilities. Why not this petitioner is, my lord?
But you had been waiting, na?
Yes, my lord. But my lord, subject to correction, I have not communicated this. I am waiting for the normal functioning of the portal. It is also true. My lord, no steps, contemporaneous steps has been
2020.
taken after my lord, honorable.
2022 was the order.
No, 2020, my lord, after the honorable single bench order, even DI is sitting tight. DI has not taken any steps. That is also, if the DI is taken any steps contemporaneously by passing the honorable single bench order, then my lord, I have to file a my lord, I have to file a fresh application before the honorable separate cause of action. But DI is also sitting tight. Kindly also visualize this situation. So, my lord, other candidate is, since the other candidate is getting benefits, that willing teacher should be, why not, my lord, I am putting this
Because
question.
they came in time.
My lord,
their
there is, my lord, no,
applications we
my
have-
lord, subject to correction.
Your section 5 is based on paragraph 9.
My lord, I am,
Please place paragraph 9.
my lord, I am subject to, when I am facing. My lord, Joyantopal, I am relying Joyantopal. Joyantopal is also, my lord, similar point has taken. My lord, Joyantopal also, my lord, more than 400 days delay. My lord, subject to correction, my lord. But delay, my lord, it is more than 400. If your lordship so direct, my lord, I can produce Joyantopal's, my lord, condonation delay application. It is more than 400. Your lordship ask the learned advocate for the state whether there is any objection. He says, no, I am leaving to it to your lordship. And as it is, my lord, it has not stated but observed, but
That
more than,
cannot. How can they concede? Try to
my lord,
understand.
only, my lord, since other candidate is getting benefits, so I'm paying before you.
They, Mr. Mitro, file a one-page affidavit in opposition.
well, it is to the state.
Actually, my lord, there is no, my lord is rightly pointed out, there should have been some explanation. That has
So
not been
give a one-line reply.
very cryptic.
He wants it dismissal to be made afterward.
My lord, moreover, the Honorable Supreme Court is saying,
Don't say all these things.
no, my
But
lord,
at fault,
no.
you have
My lord,
not
delay
explained
point, my lord, delay point. It is
Delay.
the decided
can
over Justice
express.
Dipam. I am affidavit of service is going to affirm, my lord, during the course of the sometimes, my lord, affidavit I
That is also not there.
my lord, my clerk is going to affirm. Kindly give me 5 minutes time. I'll within 5 minutes. I'll check.
ওটাই তো- কার্তিক
Your Lordship, Koeli Bhattacharya is representing the board in this matter. She is engaged in court number 8 in content matter.
Just see what is.
And I'm aggrieved by the Milord order dated 23rd February 2026, by which my writ petition was dismissed.
Yes, Mr.
Milord, my writ petition was dismissed, Milord. I challenged, Milord. What happened, Milord? My superannuation, Milord, date is as of today. When the writ petition was filed, it was, I did not superannuate, but as of today, Milord, on 28th February 2026, I have superannuated. Now, Milord, Milord, applied for correction of date of birth in my, Milord, certificate of, Milord, and the Madhyamik examination. My Lord,
When did you file?
Milord, that was, Milord, kindly comes to the
Tell us the date.
83 first. My father did. 1983. Page 41.
When did you pass the Madhyamik?
84.
Then 41 is for rectification. Why to the headmaster of? This is prior to your appointment. This letter
Yes,
of
yes.
page
At that point, I was in class 9.
all right, yes.
May I place, Milord? বিনীত নিবেদন এই যে আমার পুত্র অপূর্ব কুমার রাউত আপনার বিদ্যালয়ের বর্তমান শিক্ষাবর্ষে ১০ম শ্রেণীর ছাত্র পুত্রের মাধ্যমে অবগত হইলাম বয়স সংশোধনের জন্য বিদ্যালয়ের পক্ষ থেকে শুধুমাত্র ১০ম শ্রেণীর ছাত্রছাত্রীদের নোটিশ দেওয়া হয়েছে। বিদ্যালয়ের অ্যাডমিশন রেকর্ড থেকে জানতে পারি আমার পুত্রের বয়স ভুল আছে। আমার জন্ম তারিখ তার জন্ম তারিখ 22nd February 1966 দেখানো হয়েছে। তাই আমি আজ ইংরেজির 29 November 1983 তারিখে ফার্স্ট ক্লাস ম্যাজিস্ট্রেট থেকে করা এফিডেভিট যাতে জন্ম তারিখ 21st February 1970 ও প্রাক্তন বিদ্যালয়ের দেওয়া ডুপ্লিকেট সার্টিফিকেট জমা দিলাম। অতএব মহাশয়ের নিকট হইতে আমার অনুরোধ, rectification, Milord, to be done. Then, Milord, kindly takes up, Milord, page 42.
Have you brought the registration of births and dates act?
Yes.
Mr. Bhattacharya, this was of 1983.
83.
It was not processed.
Not processed.
You filed an application 5 days prior.
Not at all. Not at all.
Then?
Not at all. Kindly see, Milord, Milord, page 44.
Yes.
Milord, this is, Milord, the Milord headmaster of the said school, Milord. He, Milord, applied before the board for rectification.
No.
This
No,
is
no,
your application.
No. This 44 is not the headmaster. This 44 is an application made by the petitioner in 2022. Well, it kindly come. Page 45, the date, and thereafter page
Yes.
46.
Page-
Well, that 83.
Acha, Miss Bhattacharya. Yes.
Now, Milord, kindly, Milord, on the I applied, my lord, in very well. 2022, my lord, this was forwarded, my lord, by the my lord headmaster to the board. Kindly, my lord, then kindly comes to, my lord, page 47. This was sent for, my lord, for verification.
No, 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 not verification.
Then, my lord, I was called for a hearing. Then, my lord, comes, my lord, the impugned order. May I place, my lord, page, it starts from page 59. The, my lord, ultimate order is at page 61. This is, my lord, what the board has stated. My lord, may I place, my lord, this page 61, my lord, first paragraph I'm skipping over, only who attended the hearing. Kindly see, my lord, second paragraph. Shri Apurva Kumar Raut was present. My lord has got it, my lord. Was present in the hearing on 23rd February, December 2025. He was accompanied by his learned advocate, was allowed to plead on behalf of Shri Raut. Learned advocate repeated the plea that he submitted before the honorable court and emphasized that the birth certificate of Shri Raut issued on 20th December 1999 to be accepted as unimpeachable document for correction of the birth of the of his client. On scrutiny of the document submitted by Shri Raut, it is found that he has submitted certificate of birth issued on 20th January 1999 by Bagula 1 Gram Panchayat, number 2 transfer certificate of Horindanga Board Primary School, unattested copy of the relevant page of admission register of Tahirpur Lal Bahadur Vidyapit where he studied from 2 to 7 and now working
Yeah,
as yes, ma'am.
You have given two different date of births. In the third column, my brother points out, third column it is 69, 21st February. And in the fifth column, it is 70.
No, my lord, from 22nd February 1966 to it would be 21st February 1970.
Right, but then why in the third column date of birth is 21st February 69?
কোন country?
এই যে 69 এখানে 69 তলায় 66
Yes.
Yes.
Point as this was, my lord, forwarded by school, my lord.
Huh?
No, no, no.
Yes,
That we will, that we
Filled
will,
up by the petitioner.
that is the court has recorded that it was filled up by you.
Yes.
This was
এই কলামটা
Mr.
headmaster
Bhattacharya, now 83 your father applied. Court rightly discounted that that was not taken up further contemporaneously. Then you waited for a long period of 20 years. 90, what
38 years.
Huh?
38 years.
And 5 days prior to retirement, you filed the application.
no. It was, kindly see the date of, my lord.
Very good. That was directed to be considered.
To be considered, they kept it pending from 22 to, my lord, 25.
So, Mr. Bhattacharya, you kept it pending from 83 to 23.
Yes.
My lord, that is there, my lord, but
Yeah, it's a lost case, Mr. Bhattacharya. How can we help you?
No, my lord, kindly.
Unimpeachable document is the birth certificate. Now, birth certificate you did not produce.
But
with
at that
your
point of
application.
time, there was no question of, my lord, when
Why?
66,
Why?
70,
The act was there.
69.
Even in 83 act was there. কি করে করবো?
So, Bacha, I have produced now.
What bacha? That is 99 issued Pradhan certificate.
No, he
That
is
is
the
barred under section
Yes.
13 of the
Yes.
Constitution.
Yes.
It has to be of an executive magistrate.
Lordship.
কি করবো?
But the the learned single judge has
Dealt with all your contests.
true but
Because the board rejected it.
ultimate finding is that is a factual finding. Read court cannot go into it. That is the ultimate.
No, no.
finding. That is the ultimate finding. That is a factual finding by the board. Reach court cannot go into.
Unnecessarily your pensionary benefits will be stalled.
Yes.
If we keep the matter pending,
That is
they will not sanction your pension. They will say, let honorable court decide, then we will. নিজের পায়ে নিজে কুড়ুল মারা।
instruction.
And your lordship,
Kindly takes it up.
No, we could have entertained Mr. Bhattacharya, but this fact is, you have no document. And the court
No, the
recorded
school
that
document, it was produced. School register was produced. Madam, a second.
school register was right. In your school register, it was 1966. Come
Yes.
to your school register
Yes,
now.
yes.
Page 33.
Yes. Kindly see, first,
Yes, serial
Apurva-
35. Your
Yes.
date of admission was 79. And in the next page, your date of birth was 21st February 1970.
horoscope. On
Yeah,
basis
date
of
of birth.
horoscope.
Date of birth. Date of birth is 21st February 1970.
Right, but it is not that on the basis of this, that also the court dealt. Because kindly come to the order impugned.
Yes, yes, that is there.
That is also there, Mr. Bhattacharya.
But the one there is one
ওই
circular.
such and such pray হবে কিন্তু প্রেস করো না।
That has to be unimputable document. That has to be taken.
Well, one circular, my lord, of
আচ্ছা, let him finish.
No, ওই circular টা।
এটা।
Yes, Millard. Then Millard, kindly post it on Monday. We will take instruction.
মানলে কি করে হবে?
Very well. Whenever your lordship,
No,
Millard,
for what? Adjournment for what? Till
Millard, whether to at all press this or not. Because we have Millard already.
you withdraw, Mr. Withdraw the appeal.
Yeah, Millard. Then next week,
আমি একটা
Millard,
কপি রাখছি।
well, he will take written instruction, Millard. If Millard, whenever your lordship is available, Millard.
My brother has gone through it. I have gone through it. There is no window through which we can help you. We
Millard,
understand
kindly
here.
appreciate my-
Understand here.
There is no malafidness. My father had applied when I was Millard, not even past Madhyamik examination.
Mr. Bhattacharya, you are working in a school.
Yes.
Finance department circular say
Yes.
for argument's sake, it was not within your knowledge. Maybe you have came to know and contemporaneously made the application, the situation would have been otherwise. But here, Mr. Bhattacharya, you first preferred a writ petition that you are not considering my case. Court was benevolent enough to say that consider and pass a reason. After that,
Our finance department.
suffering a
Millard,
dismissal will affect, create problems for you.
that finance department circular, Millard, has been considered by a Millard coordinate bench of your lordship. Millard, it has said that is not an absolute bar.
No, accepted. It's not an absolute bar. Still, can we help you?
That is
Yes, Supreme Court on repeated decision has said.
Even very
Don't
recent
entertain
judgments also.
applications which are filed
Within
just
5
prior
years.
to retirement for the purpose of.
And again, within 5 years from joining service, it has to be done, your lordship. There are series of judgments of Supreme Court on this. Today I'm not handed over, but এটা তো ফার্স্ট জাজমেন্ট, এটা বেস করে প্রচুর জাজমেন্ট হয়েছে, এর উপর বেস করে অনেক জাজমেন্ট।
this is Millard where Millard the our division bench has Millard. না, আপনি অপোজ করেছেন আপনাকে।
Otherwise, we will consider your statement and we'll pass an order. Here and now, we will pass the order. not an issue.
করেন না কি হবে রেখে দিন।
Lordship, withdrawal, my lord.
Yes, yes.
Your advocate on record won't be embarrassed now. He will not say.
Withdraw is not possible, my
They
lord.
want an order of
Withdraw.
Order of this court, then lordship
Withdraw.
kindly pass on.
Yes, yes. Withdrawal, my lord, is not agreeing, my lord. Client is not
All
here,
right.
my lord. But only, my lord, this judgment, if your lordship, my lord, once consider, my lord.
এই যে
কি রে, দৌড়ি?
এই আরেকটা কপি
Da, 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 17, 4,
বলে দিয়ে কপি দাও দিয়ে দিতে
18,
But
volume
may
1,
also consider the judgment.
এরপরে অনেক হয়েছে
This is the 1994 6 SCC is the possibly one of the first judgment.
with the finance
And basis of that, there are series of other judgments also.
but
Well, based on this judgment, the finance department notification was issued.
this is the parent judgment.
Parent judgment, তারপরে প্রচুর judgment আছে।
this is
That's
our division bench, is, my lord,
এটাই রয়েছে।
পুরো আছে।
on, my lord.
No, suppose we are accepting your. Suppose it is not mandatory. Still, how you can get any benefit? These judgments are not required also. We are accepting your submission, it is not mandatory. Then also you are not coming within the ambit, na? You play, see the
Kindly see, my lord, the impugned order, boards.
It was in the year of 99. That too from the division of it has to be by executive magistrate.
হ্যাঁ, it is magistrate কি করে বাদ certificate?
what you are showing us, Mr. Bhattacharya.
Lord, that page 62, my lord, ultimate finding, my lord, is, my lord, the name of first is how can the Bogula 1 Gram Panchayat can issue that? Because when I was there, the act itself has not come into force when I was born.
No.
No, but act was of 69.
9,
Yes.
9.
You are
66.
You are
They say 66, I was in 70.
now kindly, when did you obtain it? 1999.
Yes. 1999.
So you were 19, if we take 66 bond, you got this certificate which you have annexed. That is at page
Page 31.
no, Panchayat certificate
Lordship, page 31.
31. See, this is of 99. That is
Yes.
10 years after your birth in 1970. Section 13 read, if there is a delay more than 10 years, you have to obtain from an appropriate authority.
And
So,
SDM is the
প্রধান of the Gram Panchayat
Cannot.
cannot. আচ্ছা কি করবো? সকালবেলা dismiss করতে হবে। The present appeal has been preferred.
He wants, my lord, he wants that.
my lord, withdrawal, my lord, he is not agreeable. my lord.
So let's have an order of court.
I
Yes.
understand your point. That is
Yes.
the But we don't find that prayer in the
That is. But that is not there, but it is from the impugned order, it appears that the challenge was there.
preferred.
এখানে চ্যালেঞ্জই করেনি ওটা
The said being which was preferred, praying for issuance of necessary direction upon the respondents to incorporate the actual date of birth of the petitioner.
আচ্ছা
To incorporate থেকে
না,
quote আনছে।
না না যত
To incorporate the actual date of লিখে দাও, to incorporate the actual date of birth of the petitioner,
একটা ব্যাপার
that is 21st February 1970 in the records of the West Bengal Board of Secondary Education. Bracket A, hereinafter referred to as the board, in respect of certificate of Madhyamik Parikha 1984.
Milord, I appear, Milord, for the appellant.
Respondent petition.
I am for the response number 2 and 3.
Service. Service.
Yes, Mr. Dutt.
Yes. But this matter, Milord, has a long trail of litigation.
So what is the wrong with the order, Mr.
Milord, the
Ask
problem
your
is,
client to appear and say that a fresh order has been passed.
yes,
Then
Milord, the learned judge, but that has been
the
informed.
only direction is appear.
May I say this, Milord? The learned judge was informed that a fresh reasoned order has been passed. But the learned judge is of the view that the previous direction of his lordship was to give all the benefits, not take a decision.
Was to
But according,
comply with the order.
yes,
He appeared and said, I will comply with the order.
yes, now comply with the order means to pass a reasoned order.
So very good. Tell the judge.
That has been told to the,
No, on that day, tell the judge.
no,
Mr.
that was told.
When was the order passed?
29 January.
29 January.
29 January 2026.
Yes.
Acha, and when was the writ petition order passed?
23.
Eh?
23.
9th of September 2024.
9th of September 2024. Where is that order, Mr. Dutt?
At page 48.
Page 48. Volume 1. Volume 1.
But in volume 1, Milord, page 48, kindly have a look. But I need to, Milord, place a division bench order, but please have a look to this. Learned counsel appearing on behalf of the petitioner submits that the petitioner was exonerated in the criminal case. Even the college authorities had to reinstate him after a departmental action. The division bench of this court, this judgment where I'll place, a division bench of this court directed his dues to be paid by the college. The college decided to pay all the dues, but stated that a reference had to be made to the DPI. Yet, till date, all the dues have not been paid. Learned counsel appearing on behalf of the college authorities submits that they have done all they needed to do and placed relevant documents before the DPI. Learned counsel appearing on behalf of the DPI relies on the statement of facts which is taken on record and submits that the college authorities did not send all the necessary papers and even said that the petitioner did not cooperate by signing a document. At this stage, the learned counsel appearing on behalf of the petitioner submits that he has not been given any notice by the college authorities to execute any document. In view of the above, let the college authorities and the petitioner appear before the DPI on so-and-so date with all necessary documents. If needed, the petitioner shall sign all relevant papers and the college authorities shall also hand over all relevant documents to the respondent number 2. Within 2 weeks thereafter, the respondent number 2 shall take a decision as required and communicate the same forthwith to the college authorities. The college authorities shall thereafter do the needful writ petition disposed of. Now, Milord, this refers to a division bench order. Now, kindly have a look to the division bench order. The division bench order, Milord, your lordships would find, Milord, at page 42, where it starts at page 38. Please take note of the relevant portion. At page 42.
In 48 order, there was no reference to the appeal court order.
Yes, first paragraph.
There was reference at page 48.
Yes, yes. The first paragraph, please come back to me at page 48 once more.
Division, yes.
The first paragraph, my lord, is found, the
Yes.
fourth line. Now, the division bench order is, my lord, at page 42, the relevant portion. May I place that part, my lord? Please take the last paragraph at page 42. On such consideration, we feel that the college authority shall revisit the issue on the basis of the representation to be made by the petitioner appellant on the inquiry report as also on the acquittal of the criminal proceedings as, in our opinion, these are the relevant considerations that are necessary to be taken into for the purpose of deciding the eligibility of the petitioner for pension and other retirement benefits as also salary for the period the writ petitioner worked in the institution. These findings would also be helpful, in our view, for the Director of Public Instruction, West Bengal, to take a decision. Now, what is to be decided? To take a decision for sanction and disburse any amount if found to be payable to the writ petitioner in accordance with law. Then please take, my lord, the next page. In view of the fact that the inquiry report is available with the petitioner appellant, 4 weeks time is given to make representation on the inquiry report and make any other representation that the writ petitioner feels it necessary in justification of his retirement and other benefits. The governing body of the college shall dispose of the representation within 4 weeks thereafter by a reasoned order. Now, the next paragraph is very important. We, however, make it clear that the governing body shall decide the matter impartially, fairly, and without being influenced by any observation made in the alleged report by Jayati Ghosh and by the learned single judge or by this court with regard to the merits of the claim of the appellant. So everything is open. Then, my lord, the next order is passed, which I have already placed. Now, my lord, the order under appeal, please have a look to this order, which, my lord, we give a hearing, the DPI gives a hearing to him, where the reasoned order is passed.
Give a hearing?
Yes, yes.
When was that?
My lord, it was,
19.
this was given that.
There was a specific date mentioned
Yes,
in the order.
beyond that, but hearing was given. Hearing was given.
Hearing.
So the hearing notice, my lord, will find that page.
Hearing was given to you. Hearing was given.
No, college authority already took a resolution in my favor. We have given all these documents to the
13th of September, any hearing was conducted? All right, take yours. Very good, Mr. Dotto. Now, the order has been passed.
Well, the recent order, my lord, has been passed on 29th of January 2026.
29.
This your lordship would find it at page 190 of the second volume, my lord.
Now, rule was issued prior thereto.
Yes. Now, my lord, in this recent order, my lord, I will not trouble your lordships in its entirety.
So, Mr. Dotto, you can appear and tell the judge.
That was told to the judge. I have told to the judge that the recent order is with me.
That is a new cause of action. Now, you
Yes.
can.
My lord, yes, the honorable judgment, with respect, did not even allow us to communicate this recent order. With respect, my lord, I am saying so. Now, kindly have a look to me the order under the
order. First of all, it is a contempt appeal you have taken.
Yes.
First of all, is an issue of maintainability, no order of punishment passed. Simply, you have been asked to appear and explain. So, when you are appearing, you certainly can explain to the judge. Unnecessarily, why you have not been
my lord, what is passing through your lordship's mind, my lord, I am definitely going to, my lord, explain that, my lord, and clarify, my lord, from my point of view. But please have a look to the order under appeal. But before that, my lord, your lordship may kindly take, my lord, page 186, the immediate previous order that is dated 5th of December 2025 at page 186.
That is issuance of rule order. 186.
Oh, my lord, this is where, my lord, time is paid by us.
Oh, achha.
Learned counsel, appearing on behalf of the alleged contemnor, submits that his client has preferred an application, praying for further time to fully comply with the order passed by this court. Learned counsel, appearing on behalf of the alleged contemnor number 2, submits that his client has already complied with the order of the court, that is the college. On the prayer of the learned counsel, appearing on behalf of the alleged contemnor numbers 1 and 3, the prayer for extension of time to comply the order is allowed. Let the alleged contemnors comply with the order within 8 weeks. So I get 8 weeks from 5th of December 2025 to comply with the order. Then, my lord, 29 January, the order is recent order is passed. Now, when we come back to the court, please check the page, my lord, 188, the order under appeal. May I please, this learned counsel appearing on behalf of the petitioner submits that this is a case of further and or aggravated contempt. The alleged contemptor had earlier appeared in person and prayed for time to comply with the order, but thereafter did a complete volte-face by purportedly passing an order to the contrary, as if he is sitting in appeal once an order passed by this court. Learned Advocate General representing the contemptor submits that there is difficulty in complying with the order passed by this court as the relationship of master and servant has ceased to exist. In fact, the alleged contemptor has purportedly passed a reasoned order in this regard. So this is noted by the Honorable Judge. It is indeed very surprising to hear such submission on behalf of the alleged contemptor, especially when it is advanced by the learned Advocate General. Had the alleged contenders being aggrieved by the order, he could have fairly challenged the same before a superior court. But the alleged contender chose not to do so. After the rule was issued in this matter, he appeared before this court and prayed for time to fully comply with the order. In violation of such undertaking, subsequently the alleged contender passed an order, purportedly a reasoned one, claiming that the order passed by this court could not be implemented. The order is not before this court, nor is there any cogent explanation advanced as regards the non-compliance of this court's order. However, in the interest of justice, this court wishes to grant another opportunity to alleged contender to explain his conduct. Let the alleged contender appear in person before so and so, annexing a copy of the purported order and his explanation about his alleged non-compliance of this court's order and about the violation of the oral undertaking to comply with this court's order on the next date of hearing for further proceedings.
Where is the order issuing rule, Mr. Dotto?
Well, the order is.
These are the 190.
No, no. Rule issue.
Rule issue.
Well, rule issue is
Order is না rule issue যেন প্রথম দিচ্ছে So your argument is that court granted time to us to comply with the order.
Right.
So on the basis of that 8 weeks, we passed the order.
On 29 January.
On 29. So this 29 January is the order ultimately passed.
Yes.
Court did not say that you disperse everything, but you take a decision.
Right. Division bench said.
Division bench as well as the single judge subsequently said that yes, you take the such decision, appear on 13th September here and take this.
Right.
So your contention is that if the court itself has given time for 8 weeks by an order of 5th December, I have been asked to appear.
Yes.
That this, Mr. Dotto, you can explain to the judge.
Milord, with respect, Milord, everything was explained. Still, Milord, the Honorable Judge felt that, Milord.
Mr. Advocate General, when the court, single courts has felt necessary that the officer must come, can we interject at that stage?
But on that, Milord, may I make some submissions? But the first thing is, Milord, your Lordship will kindly.
You go and appear. What is your problem, sir? You won't be sent to jail when you are explaining this conduct.
Milord, the finding is already there. Kindly comes back to that order, Milord. 17th of February.
That is, where is the rule? Where is the order issuing rule then? Anything was recorded there?
Next quarter. I'm sorry, Milord, it is not annexed. First.
He cannot operate the sophisticated taps. Can you, my brother can.
My Lord Justice Chakraborty should upgrade. But after next week, my Lord, there'll be someone to, my Lord, teach your Lordship.
It has complied with the order and has done his books. So because but the petition booklet could not be submitted. The petition did not sign the booklet. The same is denied by the petitioner.
Contemptor 1 was DPI.
Yes.
Contemptor 1.
That is not represented by the issuance of notice.
You did not appear on that date. Nobody was there on your behalf.
On 14th August.
Who is contemptor number 2? College.
College. But on 14th August, my Lord, none represented the contender number 1.
Choose not appeared before the date for
However, it is very unfortunate indeed that the alleged contender number 1 is not represented despite issuance of notice. So he was not present.
You are not present on that date.
No, no. We are not challenging the rule issuing order.
Then
That will not the court
then
can.
what is your challenge today? Tell us.
Thereafter we appeared.
But there
I
are
will not appear.
no, personally appear to yes, he had appeared personally. It is recorded in the next day's order.
Very good. Now, what is your stand today? That I will not appear, you stay the order.
No. Today, my Lord, the learned judge, my Lord, my understanding is that the learned judge is proceeding to punish the contemptor.
No, we will observe that. We will observe that your contention that it appeared on the date rule was issued, the contemptor was not present. Right?
Contempt number 1 was
Not present in spite of notice.
However, it is very unfortunate.
So we will record your contention that he was not there. Second, there was no. In fact, he appeared on 5th of December when the court itself. এটা কবে হলো orderটা? 5th of December. That is after 14th August.
Right.
He appeared and it was given time to comply.
Right.
And within that time he has passed the reason.
Right.
So this fact will be, you will be free to urge this point by appearing before the court. We will make it clear.
My Lord, first thing, my Lord, let me clarify myself. My Lord, I, as a counsel, as a stakeholder in the judicial system, cannot say that my client will not appear. In fact, he had appeared. The purport of this order.
After this, he appeared.
Yes.
After 5th August, 14th August.
Yes. See order to bear করতে
On that day, he gave the
Where is that order, Mr.? Want to take back here? এটা একটু ওনাকে দিয়ে দাও।
That very day, he gave an undertaking that it will be in precedent court.
Miller, that is dated
11th.
11th of September, Miller, present in court.
Read now.
Affidavit filed so and so. The director of public instruction so and so is present in court and is also represented by learned counsel. But this is on 11th
September.
11th September. Learned counsel submits that the alleged contender number 1 has retired. However, the DPI seeks some more time to fully comply with the directions of this court. The DPI has asked for relevant documents from the college, some of which has been given, some other documents are required to be sent. Learned counsel appearing on behalf of the college submits that they will cooperate with the DPI for complying with the court's order. Whatever other documents are required and are available with the college would be supplied along with necessary clarification. On the prayer of the learned counsel appearing for the DPI, list for further consideration on 4th of November, leave is also granted to add so and so.
DPI dispensed with.
The presence of the concerned DPI is noted and dispensed with for the present. So he appeared. Therefore, that's why, my lord, I wanted to
I
clarify.
said I will comply.
I will-
Extend some time.
Yes. Then time was given on 5th of December for 8 weeks. Within 8 weeks, we have complied with it. Or we have passed a decision. Right or wrong, a decision has been passed. Now, once a decision has been passed, as rightly fallen from the court, it gives rise to a separate cause of action. Now, if this is the correct position of law, now Miller calling upon the person concerned to once again appear, Miller leaves us with nothing but to get the punishment because of the findings in the order of 17th of February. The learned judge notes that we have passed a reasoned order.
So your argument is court has already arrived at a point
Right.
that now there will be no option.
No option but to punish my client.
It's a bit of overthinking, Mr. Dotto. If you appear, certainly this point will be taken. Once you appear and with responsibility, that penalizing the person in your view is not required because apart from the court, he has taken extension and he has passed it within. In appeal, we need not go in because you have been asked simply to appear.
Miller,
And the observation in the first paragraph.
Yes.
So observation, your submission we will record, but that will be on record. Court will take into consideration, but need not interfere when the officer has been asked to come and make his case.
Subsequently, the contempt passed an order purportedly
Like with the order.
Well, let him finish.
But on 2 points where if your lordships require, my lord, I can address your lordship. One is, my lord, maintainability of an appeal from an interlocutory order passed in contempt proceeding. And the other is whether, my lord, and any additional directions can be passed in a contempt proceeding which was not considered while disposing of the initial matter. If your lordship requires, my lord,
What is your answer to that, Mr. Dotto, that it is not an order of punishment, how the appeal is?
my lord, interlocutory orders, my lord, are all in contempt proceedings are also, my lord, appealable, my lord, under clause 15. Just two very short judgments on that. Very short judgments. Because if it vitally affects somebody's right, my lord, these are appealable.
does not vitally affect somebody's right.
It has not affected your rights, Mr. Dotto.
Merely a speculation that
You are thinking,
Overthinking.
Huh?
Overthinking.
Exactly. I don't it. Every court is, when you go and explain to me,
My lord, we have explained, my lord. The recent order has been passed. Please consider, my lord,
and you say that word that my lord's order, my lord has proceeded on the basis that you have said you will comply. Why you have not complied? My lord has proceeded on that basis. But the fact, as you have elaborated, that argument is not dealt with in this order.
my lord, what is not recorded in the order, I cannot say, because, my lord, the court's observation in open court is that the court felt that you pay all the benefits. Why have you taken a decision? That is the court's view, but it's not on record. What can I do?
Let that view come, then you come to us.
And my lord, after I am sent, then my lord, section 19 appeal will lie. Then clause 15 I cannot invoke.
Criminal was expected to give a reason of the percentage that you have done.
These are
Steve.
You took a different point, that is cessation of relationship, nothing to
So that, my lord, the college, my lord, I do not know, my lord. After dismissal, how can there be a reinstatement? That, my lord, I cannot fight with the college because he's a part of my administration. But something must have happened for which, my lord, 16 years out of absence. 16 years. And I have to pay all retirement benefits to that person. But I will not prejudice your lordship with the other allegations. The other factual prejudice I will not put. Take back that person without a court's mandate, without a court's direction. But I will not bother your lordship.
the age. Yes,
No. Yes,
so his terminal benefits will be guided by the conditions existing on the data. Yes, what are you saying?
Regarding maintainability of the appeal in connection with a contempt proceedings.
Is there any objection on your part? If we record Mr. Dotto's
Yes,
argument-
objection to that extent. If objection to that extent.
Yes.
Because of the fact whether my lord will entertain or holds it maintainable, then my lord observation subject to correction, my lord, comes. Now, who preferred the appeal kindly sees first. Whether contempt has come before your lordship, whether learned advocate general can appear on behalf of the alleged contemner in a contempt proceedings before your lordship, that is to be decided by your lordship then. Let there be a my lord, exclusive, because the conduct of the alleged contemner, my lord, I shall place one after one. Appeal preferred by the state in a contempt proceedings. Whether it is maintainable, it is to be decided first by your lordship. Because it is contemner and the court in the contempt proceedings first. Even then, whether learned advocate general can appear to argue on behalf of the alleged contemner because he is appointed by the honorable governor to deal with the constitutional argument. Because he is to liable, the person concerned.
There is a state function.
Not that. No, this is original proceedings, not it is. It is a special proceedings. It is not the original proceedings. He can appear in the original proceedings to defend the state.
Sir, if we record, we are.
But it is not, cannot be. Let.
We cannot record what an
No,
argument.
argument can be recorded, but
That is
observation.
what we are-
My lord.
We are recording Mr. Dotto's submission that the court has the orders which he has placed before us. Simply, we would be recording, and by the officer has been asked to appear and explain his conduct.
My lord, subject to correction. Subject to correction. I have some restriction to argue with your lordship. My lord, that purported order, if produced in a contempt proceedings, it must be filed by a compliance report. Subject to correction, I have learned from this honorable institution. It was not done. Only submission was made. It is order passed. So accept this. It was not placed according. Kindly see the order itself. It was not produced. Argument done. And what was the crux of the order? Following the honorable division bench observation regarding main fact. Initially, termination order was passed.
What was the division bench ultimate order?
Ultimately, hold take
Page one.
decision 48
Take a decision.
Decision.
All the bench-
There are certain observation regarding that. He has not read the observation to that.
Not required.
That is.
The ultimate direction is that you pass an order.
Order has been passed in my favor by taking resolution by the managing committee.
No, you were asked to appear before DPI on 13 September. Please come to page 49.
49, yes, that is there. Why? Because that resolution, which what?
Tell us what is the order. Page 49. What is the direction upon the content? Yeah, both of you will appear before the DI on such and such date. If needed, petitioner will sign, and within 2 weeks you pass a decision. 2. Respondent number 2 shall take a
Yes.
2 is the
Now, my lord, if lordship kindly take 46 page. My lord is not going to that order itself. It is not under challenge before the honorable division bench today. This order of page 46. Initial order by which Justice Sengupta was pleased to dispose of the writ petition taking consideration of the honorable division bench order judgment. My lord, kindly sees the college presently has no principal. 46. It is the judgment of the on compliance in division bench judgment. Why I am placing? When the honorable division bench initially passed the judgment, which was page 38 to 42, the college authority did not take any decision. My lord, take the note regarding my entitlement of pensionary benefit. Because I was initially.
We are wanting to know it has culminated in an order. Contempt is against which order?
Contempt is against order.
9th of September.
Correct.
So 9th of September order said that both parties will appear and the DPI will take a decision within 2 weeks.
My lord.
Communicate the same.
Correct.
This is the order.
Correct.
Now kindly come to page 81, 86.
Yes.
That order, when contempt, when you file contempt because no decision was
Taken.
communicated, they did
My
not.
lord, my lord.
Now, after it filed the contempt, they said that give us some time to comply with
Comply the order
each order. Order
of
at page
97.
49,
Correct.
Page 49 said take a decision. Take a decision. Now, this time to this decision taking period was extended by the court. On the leave granted by the court, within the period extended, they passed the order.
Yes.
Then in that case, Mr. Vishwas, how the court can perceive this, that issuance of that order itself is contempt. Can that be perceived?
That is, well, if it is not, kindly see is the application. They have filed an application.
Forget about everything.
My lord, kindly.
Ask me one thing, that an order has been passed. If the court does not take into consideration that fact, natural consequences will follow. We will ask the person to appear and explain his conduct.
Or any interference of the order,
You are not interfering.
any observation or interference, only in your lordship can record this. But any observation, unless until your lordship holds, well, I have that judgment against that order itself.
Have we said that we will make independent?
Well, subject to correction, but subject to.
Record Mr. Advocate General's submission to this effect, that this earlier order, time to take the decision was extended by the learned single judge by this order, and within that time the decision was taken. Read this submission and the objection of yours together with the line what the court has said you ask appear. We will say that
Let
submission he can certainly appear and explain the
subject to correction. Kindly before that, kindly take what was the stand for extension of time by filing the application by the contemptor. They are saying we have passed the reasoned order. All right. They have said that we have made the application before the finance department to comply your lordship's order in total.
We are not on that. We are saying that we are not interfering with the order.
My lord.
We say that the court has directed the contemptor to appear and explain his conduct.
My lord.
So for this explanation of this conduct, the submission which is made before us, naturally that will be told before the judge. We will record our order in that manner that this explanation will be this which he has submitted. His explanation will be this reason which has been given.
Let them say before the honorable single bench.
Naturally, we are saying that will be told before.
That is why whether appeal is maintainable, that is to be heard first.
Are we entertaining? Are we entertaining?
No, subject to correction.
We are dismissing the appeal.
I got your lordship's point. But what is passing through my mind?
Appearing in person, go to jail, that is
No.
motive.
No.
Motive is whether there has been intentional and deliberate violence.
Yes. But
so can a contemptor cannot appear before the court and say that this is the steps which I have taken in terms of your earlier order. You please consider whether this is deliberate violation of my lord's order. Can a person not appear?
Obviously, that is not the purpose of letter patents appeal. It is not maintainable under clause 15, as your lordship.
Have we taken that ground? We are not interfering. What can be your other submission? Had we entertained the appeal, we can ask you to pass and give an affidavit to that. Will that serve your purpose? If we give affidavit, he will be jumping and tell us that don't ask the officer to appear.
My officer will appear. Please decide this. Keep the appeal pending. My officer will go and
the appeal. Kindly let me. I am thinking that whether appeal by the state is maintainable, kindly hold this. It is appeal preferred by the state in a contempt proceedings. It cannot be maintained. Your lordship passing any order.
We cannot pass the order of dismissal also.
No, that I am not on that. I am not on that. Regarding any observation, any submission.
Sir, if we pass an order of dismissal, does that mean that the appeal has been entertained? We are at a loss to understand.
Or I am on, what can be said? Regarding clause, chapter 10 of the appellate side rule, judgments, and my lord, kindly take note of chapter 10 also. Chapter 10 of the appellate side rule.
আচ্ছা স্যার
Because it does not come within the purview of judge. My lord.
What am I to explain?
You have said that argument will be taken into consideration. That argument which was
But before the learned single judge, I have to go and explain my conduct.
you have to explain that these are the sequence of facts. Court has not taken note of that fact according to you that it was given within the time frame.
The court is not proceeding on that basis, Millard. I am very, well, this is the most difficult part.
That is why you are here.
But the court says, Millard, the court has said why he has been asked to appear in person.
We have specifically recorded, Mr. Dotto, that the order was passed taking as per the direction passed by his lordship himself. Now, if you argue one thing that this fact will not be taken into consideration, this Mr. Dotto.
Millard, your lordship has been pleased to record my submissions. There is no.
Your submission was cessation of relationship, nothing.
No, not on that, not on that.
It has construed in that manner.
Millard, if the court says that my order was to release all the benefits, and I have been in fact asked to explain that.
My lord, kindly see paragraph 5. They have made the categorical statement. I am bound to show this. This has not been annexed. My lord,
The order.
my lord, I can leave. My lord, obliged to your lordship.
Again, we have to talk.
Let us see. Much obliged.
When the advocate general appears, usually what we think that in matter unnecessarily a person will not come. We understand that. But the thing is, our brother will appear and make a submission. Your submission will be weighed by his submission.
Yes.
I said that you are overthinking. That is because of this reason. That is my perception.
Something was
there are
appeared in innumerable contempt matters before us. We never, first instance, we ask, oh, who is appearing? Advocate general. Then when you appear as the functional head, we trust and faith that the issue will progress. Otherwise, many matters will come and say, it will be coming. The gamut of the litigation can be further explained.
And that is why one line observation is there. Since the advocate general is appearing, that noting is there. With great respect.
Due deference to the honorable Judge Millard, the use of this expression should not have been there.
No,
because I had an explanation, and I cannot say this. Millard, the honorable single Judge Millard has misconstrued the division bench judgment.
Let us come.
I cannot say this.
Let us come. Yes.
I'm grateful.
My lord, I can have
the press order of action.
ঠিক আছে অর্ডারটা পাস করবে
সেটা আমার রিজন অর্ডার পাস হয়ে গেছে rights or liabilities determined if you are agreed by the challenge that a litigation.
My lord, I am appearing for the state, my lord, in this matter.
Yes.
My lord, I am led by Mr. Jayantonaran Chatterjee, appearing on behalf of the petitioner, my lord. My lord, this is restoration application, my lord, dismissed on 13 January 2026, my lord. Restoration application, my lord. This is my affidavit of service.
13 January.
13 January, my lord. I filed this application on 29th January. My lord, kindly restored the matter, my lord, and fix a date for hearing, my lord.
My lord, I am appearing for the state, my lord.
How can we restore? This is an order passed with Justice Partha Chatterjee.
Yes, ma'am.
বললে ভালো হয়। এর মতো ও পারতো। হ্যাঁ, সাথে স্টোরেজ না।
Yes, you are appearing for me.
My lord, I am appearing for the state, my lord.
When was it dismissed?
My lord, 13 January 2026, my lord. Page number 12 of my restoration application. 29 January, my lord.
Explanation whatsoever that the appellant said that there are no willful latches on the part of the landlord both for the appellant in not attending the court at the time of call. That is the only thing. What is the explanation?
My lord, my lord, I missed the list, my lord.
Paragraph 8.
Written, my lord, I missed the list, my lord. I missed the list, my lord. I missed the list, my lord. That's why the matter was
Even that is
called on and matter was dismissed.
Then that has not been pleaded that you missed the list.
My lord, kindly, my
There
lord.
were there states that there were no willful latches on the part of the landlord advocate. That is the only thing that you have stated.
Have you served upon all?
Yes, my lord.
Where is your service upon headmaster?
My lord, I'm served, my lord.
Evidence of service? দেখো না হেডমাস্টার রেসপন্ডেন্ট নাম্বার 7 থেকে গেছে। Within time file. Evidence of service, as filed, be kept on record.
Kindly, my lord, fix a date, my lord. To be fixed.
Act of substitution.
Substitution. There is a substitution application also.
My lord, substitution was filed, my lord, by the erstwhile advocate, my lord. Because my lord, I feel my lord that the this is a change brief, my lord,
Yes,
for
my
the
lord.
appellant, my lord.
Affidavit in opposition was filed in Can 1.
Can one
That is, Can 1 is substitution.
substitution?
Yes. ঠিক আছে।
My lord, the appellant has died, my lord. Mangala Bhattacharya.
Why you are opposing?
My lord, I am not opposing, my lord. The substitution has already been allowed, my lord.
Then substitution application is not on record. In the list, it is not appearing, na?
Uh,
Be expired. When did you file the substitution application? August 25.
yes, my lord.
You filed the August 25, and when the matter was dismissed, first the substitution has to be allowed. ওই অ্যাপ্লিকেশনটাকেও লিস্ট করো, ওটা অর্ডার দিও না। দেন নেক্সট থার্সডে ইউ ওই এর সাথে ওই সাবস্টিটিউশন অ্যাপ্লিকেশনটা দিয়ে লিস্ট করে দিও। Yes, yes. Thank you for pointing out.
Extremely grateful, my lord.
Give the number, give the number.
Oh, I see.
My lord, 6, I am for the petition. Well, kindly take it up on next week on anything. Because junior is not. My lord, I made an application for transfer. I made an application for transfer that has been rejected.
We will also reject.
Page
Circle completed.
Page 54 is the order. There are some familial problem and physical problem. That's why he applied for transfer. He made a representation. That was rejected.
But now the system has changed. You already obtained a mutual transfer, no?
Earlier, earlier in a different district.
No, under the present rules.
No, from the present school, I did not.
So you have to make a present application fresh, Utshosri portal.
Utshosri, he applied through Utshosri. That was pending. That was not pending. That was pending.
Now, what is page 35? You are suffering from gynecological disorder. Then it is
Why?
an application. Then you have to make an application on medical ground. You did that representation will not serve your purpose. It has to be 21 এ করেছে. When were you mutually transferred?
I was transferred, my lord, long ago.
Long ago.
2017.
The elements of his age
2017.
from the petitioner, his wife and child at home are the grounds of seeking protection.
Where is your Ushosri portal application?
Melody.
Start part annex for me.
No, I have annexed, my lord.
Where have you annexed? You have not read the brief or what?
Today from morning, different courts I am running. Page, my lord, page 44. That is, my lord, as per information email such and such. Page 44. Prayer for transfer.
44.
Page 44 is the original application. To the Commissioner of School Education, Muhammad Abesina, such and such, working Uday Harampur.
No. This is not this. Ushosri portal at that time was operating.
Yeah, that, my lord, he applied through Ushosri portal.
Where is that? Ushosri portal, there has to be a format. It has to be sent to the DI to the school. Where is that format?
That is, my lord, because my instructions that he applied through Ushosri.
So bring us those documents. Show us that document.
Yes. But kindly on any day, excepting Monday on any day.
What is the defect?
Defect.
Have you got the certified copy?
Yes. Certified copy, with certified copy.
In time is gone. Memo needs to be classified in. Next Thursday.
Yes. Because my junior has, my lord, he has gone to Puri. Yes, sir. Next. I'm grateful.
Case 7, B7.
Lord, I am for the appeal. But there is a delay of 29 days.
29.
Section 5 is not
Appealing to the board, date by 21.
Where is he? Where is she?
It is in other court.
You have given copies to everybody.
only
Your service complete.
affidavit service. I have served only Koil Bhattacharya, he contest. Only she contest is the matter. Only
So you have to
board.
but parties have to be served, sir.
Before
2 weeks. Serve up on complete service and come.
except and all other authorities except board.
Service in the meantime. It will appear after 2 weeks, complete service.
Good.
Lordship, this is my affidavit of service.
Appealing to the state respondent.
So there's a delay of 400.
400 days.
I'll tell you, your lordship. In fact, technically there is no delay because this is an appeal against an order which was passed by the Honorable Single Bench on 19th of April 2022, rejecting my prayer for appointment as an.
Have you served upon the council?
Council is the main.
Have you served upon all? Council of Primary Education?
Not 24. Primary education and not 24.
But then
Lordship, it's there.
it's there.
There are other defects.
That, your lordship, the advocate on record is not here today. That is the main
Where
problem.
is your affidavit of service? Moreover, there are some defects in the application.
Section number 3 and 6 of the copy of the impugned order do not find placing in.
3 and 6. এইটা ওনাকে দেখো
7 and 34 days delay. Department report 7:30.
বলছি ইনফ্যাক্ট rectify the defects. The Take back your affidavit of service. It will appear after 2 weeks. In the meantime, you rectify complete service of job. Clear order. The learned advocate appearing for the
I am appearing for the appellant, my lord. Mr. Parthopratim Rai is appearing. He was here, my lord, just left. Can't you make it short?
Application is pending.
Yes, yes, ma'am. The application is pending.
What is the application about?
My lord, the application,
All right, pass over. All the list.
fine, my lord. Fine.
You are in 9. That matter.
That-
That paper book you want. Who is your other side, Mr. Chakraborty?
Actually, the writ of warrant to mainly to justify the appointee.
Anybody appeared?
Yes, it is, because they wrongly to us. In the writ of warrant, my lord, only person is appointee, not the appointer. Appointee has to justify whether his appointment is.
এটাকে কাজ করো এটাকে
আমার today's 3:30, so এক fixed date.
হ্যাঁ
And fixed date থাকে.
It's 9 now. We will take it up on the day we next call the supplements. It is, if I take it to the supplementary list above you, there will be some hearing matter. As it is 9,
Right.
so let it remain as it is. Next day when we call, because my regular partner is not here.
Yes.
Justice Chatterjee is not here. And the problem is if we pass any order, I was told that the matter has to, supplementary list has to be published. This is the problem. So Mr. Chakraborty, it is item number 9. Hopefully it will take it up. By 2 weeks it will be taken up.
But he is not out of employment for 2 weeks.
It is not called within 2 weeks.
No.
But notice to your other side and come and mention me.
Yes.
Then which? Yes, next. Criminalism. এলিভেশনের পর থেকেই তো ইনভেনশন হচ্ছে
ওনার সঙ্গে
স্টেট ট্রাইব্যুনাল Yes, where is Mr. Roy? He has not come.
He is engaged in another court, my lord.
Then we take it up on it is the first matter. So on the day we will take up combined it will be taken.
Can you fix up the matter because other side is not appearing. I shall serve a notice fixing a date, my lord.
Let it remain as it is. If it is not taken up within 2 weeks or 3 weeks, you give a notice to your other side and come and mention. Hopefully it will be taken up because we are thinking of taking up the combined list on some day from the morning. Then we will be.
To involve is, my lord, the grievance of the petitioner is against a private institution. And the petition has been disposed of without hearing the school authority.
So that matter, right?
That matter, my lord.
No
Yes.
settlement.
Yes.
So what happened? We have not stayed your order. What was the order?
Order was, my lord, to pay entire compensation for the period he worked.
Contempt filed.
Yes, contempt filed, but court, my lord.
Then once it comes up in the list, come and mention if it is not taken up by that time. If it is not taken up, you mention.
Yes. Yes.
Moreover, my brother, I was hard it with Justice Chatterjee. Today we are having a new bench. There is some problem.
That's it.
But the taken over.